As a practicing advocate, one of the most serious problems that I grapple with is court cases delaying and being very expensive. Actually, those are two. But it's not only advocates grappling with those two problems. The public, either court users, and the judiciary, which is responsible for all courts. Court cases tend to take a lot of time, which is never anyone's intention. Courts don't want it, and the lawyers don't want it. Actually, lawyers would make more money, and actually make more money, if they handle more cases in the shortest time possible. Now, today, I want to tell you about the alternatives that are available to resolving disputes through courts. And that is what is called alternative dispute resolution. In brief, ADR. Those are the mechanisms that you would use as a person having a dispute to determine or resolve your dispute. Now, the courts in Uganda have come up with some of those mechanisms to try and help in resolving people's cases and helping the people themselves to resolve their cases efficiently, cost effectively, and as quickly as possible. The courts or the judiciary is also trying to reduce what you've been hearing as court case backlog. A backlog case is that one that has been in court for more than 2 years, or 2 years and above. Now, today I'm introducing you to ADR, alternative dispute resolutions, the mechanisms that you can use to resolve your cases. We have about 4. There are more than that, but today I'll take you through 4 of them, the most common ones, and which you need to know. As our mission on the Law Podcast Uganda, to make sense of the law and consequently to help everyone listening and watching to know a thing or two basically about the law and how you can go about it. So the 4 mechanisms or methods of ADR that we're going to talk about today is arbitration, mediation, negotiation, and conciliation. Now, let's start with mediation. And this is because the courts in Uganda have made mediation a central part or a significant part of the system. I'm sure those of you who have been to court have heard of what we call court annexed mediation. Now, this is the mediation. And by the way, even before I tell you, but let me just say that court-based mediation is the one that is conducted at court. But what is mediation? Now, mediation means a third-party centered negotiation, or where 2 parties who are having a dispute have a third party who is, if it's court annexed mediation, who is appointed by the court to help them resolve their matter through negotiation, through settlement. So it happens where you file a case, the case comes to court, you file your case in court, the court then refers you to mediation. It used to be mandatory, but because of recent court decisions, the courts have now said it's optional, but very, very advisable. The courts always advise that you do it. So there's this mediator who is certified. The court will refer you to them, and that mediator will help you negotiate, find an amicable settlement of the matter. Those of you who have been at the Tax Appeals Tribunal, you've seen the mediators there. Those of you who have been to the courts, you've seen the mediators there. So what those mediators essentially do is they give you alternatives. They present suggestions to you. They invite you to come up with your own suggestions, with your own ways of resolving the matter. And it's usually very, very cost effective and does not take long. I'm sure most of the courts and the tribunals that I know, mediators are free. If not free, they're really, really cheap, if I may say. They are very, their cost is very, very friendly to people. So with mediation, no one makes a decision for you. Even the mediator does not make a decision for you, but he helps you come to an amicable settlement of the matter. And then the other advantage from that is that because you have resolved your own dispute, it keeps the relationship. It keeps relationships going. The same concept is also employed in criminal cases. If you've been to criminal courts, you have seen or you have heard of what is called reconciliation. Courts in simple matters, which are not felonies. Felonies are those matters whose punishment is 2 years and above. 2 years and above, because a misdemeanor is 2 years and below. So in those small crimes or small cases or offenses, the criminal case will advise the complainant and the accused person, or the accused person's family, or relatives or friends, or the ones representing him or her, to negotiate a settlement of the matter. Actually, this is what also informs the plea bargain. It's not exactly that, but the idea of settling or amicably settling matters to save time and cost is what informs the reconciliation, the plea bargain, the mediation, the alternative dispute resolution mechanism. So even with the reconciliation, the reconciliator does not make a decision for you the way courts do, because a judge or a magistrate will decide for you. But the mediator or reconciliator, they do not decide for you, but they help you come up with your own decision, with your own resolution of the dispute. And this is very, very important. And the courts recently, like I've said, have encouraged and continue to encourage people, court users, to take up these mechanisms because of how beneficial they are. You will not be complaining about our cases take so long, our cases, lawyers are very expensive. Those issues will not arise. The second one, which is arbitration. Arbitration is also a negotiation, but here the arbitrator makes a decision for the parties, and the parties either decide on the arbitrator. In fact, they have to agree on the arbitrator, and it comes from agreement. Parties agree that we shall not take our matter to court. We shall take our matter before an arbitrator. That arbitrator could be a person qualified in that field. Let's say if the dispute is on construction, they may choose to say that the arbitrator will be an architect from the board. And they might even agree on the name, they might agree on the appointment, they can agree on the time within which the arbitration will be conducted, how much will be paid to the arbitrator, and they also agree that this decision will be final. the arbitrator's decision will be final. So you can see that it is from the parties. They can even agree that, you know what, our arbitration will be conducted in Nairobi, or will be conducted in Busia or Masaka, anything like that. And so this speeds up the process. It helps parties, even if the construction dispute is a billion or millions of dollars, it can be resolved in 3 months, it can be resolved in 6 months, 3, 2, 1, as long as the parties have agreed. And this, like I've said, is an alternative to the court dispute. A construction dispute in the commercial court, for instance, give or take, it'll give you a minimum of 2 years. 2 years. But with arbitration, you can agree to have it in just a month, 2 months, 3 months. And the money you agree about to pay the arbitrator is usually not that high. It's a small fee. So I also encourage you to take that up. And so it means that if you're preparing agreements, you will include the arbitration clause and say, in case of any dispute, we shall have arbitration. We shall not go to court. And trust me, that agreement will be valid and will be enforceable. And your matter will be determined through arbitration. And arbitration can be 1, they can be 2, more than 2, you know. And so that saves you a lot of time and money. And you stop complaining about the lawyers being expensive and the courts delaying you. You know, we don't have, there's no justice, the courts are slow. Please take that up and think about it. Then the other one is negotiation. Negotiation, like you hear the word, you can agree to negotiate and say, you know, when you've entered into this contract, let me use the same example, construction, and say, in case of any disputes, we shall negotiate between ourselves for a period maybe 3 months. And you can include in the same contract that where the negotiation fails, we shall go for arbitration. Or you can agree that when the negotiation fails, we shall go for mediation with a third party, because mediation always has a third party, or with the person whom you can name. Now, you can also agree to give the negotiation a period of time. While I'm saying this for contracts, I also mean maybe tenancy agreements, maybe all sorts of agreements. You can have that as a way of resolving your dispute beforehand. And then we have another one called conciliation. So conciliation is in between mediation and arbitration. For arbitration, the arbitrator can make a decision for the parties after the agreement. And it's a little more formal than conciliation. For mediation, the mediator refrains and cannot make a decision for the parties. He just helps them, facilitates them to come up with their own resolution of the issue. Now, for conciliation, the conciliator is allowed to make a non-binding proposal, settlement proposal for the parties. That's the difference between conciliation, mediation, and arbitration. So, conciliation, the facilitator or the conciliator facilitates, helps the parties, bring them together, present their issues, what they would like to have, and then can make a non-binding settlement proposal. What that means is that the conciliator comes up with some sort of proposal of settlement, but the parties have the right to accept it or not. In mediation, that cannot happen. In arbitration, it's more formal. The arbitrator is given the right to make a decision for the parties. But all those processes come from the willingness, the voluntariness of the parties to resolve their matter amicably and by themselves. So, ladies and gentlemen, these alternative dispute resolution mechanisms are very, very good. They still give us money as lawyers because we advise on them. And the quicker we deal with cases or disputes, the better for us. But also, they're very good for you because they save you time. They allow you to own your cases. They allow you to own and resolve your disputes. Even if it was a family dispute. Actually, my experience has taught me that when a dispute is amicably resolved by the parties, even the relationship is maintained. Maintaining good relationships is very, very key. So rather than having a case determined by the court or a judge, magistrate, and even the children will carry on with that fight. They will never believe. You've heard of appeals and what. In these mechanisms, I'm telling you, there are no appeals. Why do you appeal when you have agreed? Why do you appeal when you have amicably resolved your own matter? There will be no reason. So when we have disputes cannot be avoided in society. But when you have them, kindly seek out the lawyers to advise you on the mechanisms I've told you, to advise you on the mechanisms I've told you about, and to allow yourselves to use them. They're available at the courts. Whenever you go to court, the court will give you a chance because of the advantages I've told you, being fast and cheaper. They're available at court, they're available at tribunals, they're available at bodies, they're available at... last time we had the insurance complaints, the Insurance Regulatory Authority here on the Law Podcast. And they also talked about mediation when they're resolving their complaints, when they're resolving complaints that go before them. And so, ladies and gentlemen, I want to, while we are getting this knowledge today, I would like to invite you and implore you to use the alternative dispute resolution mechanisms that I've talked about. That is arbitration, mediation, conciliation, and negotiation. You'll never regret. As always, I am Alexandra Kafero, the host of the Law Podcast Uganda. Now, we continue to invite you to subscribe, watch, and in the comment section, kindly tell us what you'd like to hear about, what you would want us to talk about in the next episode. And depending on what people say, we shall pick them out and always make that presentation. Thank you for watching, and thank you for listening.